to do is that each of the lawyers are going to introduce themselves, and then they're going to speak for a few minutes, and then we'll open it up for Q&A. Okay, so who'd like to go first?
We're doing just the introductions?
Just introductions and talking for a few minutes, and then they'll go to the next one. Okay? It's up to you.
Sure.
Check we got mics there.
Checking the microphone, is it on? Good.
Is it on? Yeah, we're good.
Great.
Thank you.
So, hello, everybody. Thanks for coming. My name's Taro. I'm a criminal defense lawyer. I'm doing a pretty small fish in the criminal defense aquarium. And when Sue asked me to. Is this better?
No.
Not really.
Closer.
Okay, how about this?
A little bit better.
Okay, now we're testing 1, 2, 3. We're good. Is it a matter of me just speaking louder?
Yeah.
Possibly.
All right.
Do you want the microphone?
Yeah, that might be better.
I probably speak more soft.
Oh, sorry.
Okay, how are we now? Oh, I think I can hear it.
And is that better?
Testing 1, 2, 3.
Yep.
We're good. All right. Okay. So when Sue asked me to participate in this last week, I had to look up what the conference was about, and clearly it was about male victims, among other things. And just on that point, I'm here ultimately. I think ultimately this is going to turn into in my discussion with my colleagues, largely a Q&A session. And I would be one of the criminal lawyers on the panel. And one of the, just to start off with, for a conference on male victims, one thing I'd like to clarify, at least just purely within the criminal law context, the concept of a victim is the word, the victim is a little bit of a contentious issue. And just to explain why, the criminal litigation, which is mainly what I do, involves ultimately a judge finding a person guilty or not guilty of a criminal offense. And there has to be a criminal offense for there to be a victim of a criminal offense. So in the trial process, or the process leading up to a criminal trial, to call somebody a victim itself is considered a loaded term by certain people. That might reflect my bias. It's the defense that takes issues with that terminology. So often the term we use is a complainant. Complainant is definitely, it makes sense. It's the person who's raising a complaint about criminal activity, and ultimately the factual issue gets resolved at trial. And I think that makes even more sense when we consider the context of this conference, where we're thinking about what it means to be a victim. And mention has been made by other speakers of where the victim is really the person who was charged with a criminal offense. So conceptually, I think it makes particular sense for us to talk about complainants and victims, and to think about which we're talking about when we're discussing this issue. So Sue asked me to participate in this. I understood that it's largely a question and answer session. And so maybe a little bit of background. I think ultimately Sue asked me to do this because I participate once a month in a legal clinic with the Center for Men and Families. And again, that's largely a question and answer session. And I've found certainly that when the clients come in, they have questions. There are a lot of similar questions, and therefore a lot of similar answers. And often the questions are based on misunderstandings of what well, the law, the criminal law, actually involves a criminal procedure or the court system. And if ultimately I answer for this session, I answer questions. I just wanted to be, before I pass the mic down, I wanted to just point out just a few of the basics that often should be understood in order, just so that the my answers will sort of make more sense. And I'll give you examples of what I'm talking about. In your basic criminal case, criminal complaint is made, the police investigate, a person's arrested, and that person goes to the court system. So I just want to explain the roles of the various parties and how it might be a little bit counterintuitive. So let's start with the complainant, the victim, if you will. I prefer the complainant. Typically, that complainant is not represented by a lawyer. They can be, typically they're not. Instead, their primary point of contact with the larger system is, at least in Toronto, the Victim Witness Assistance Program. They are people who are charged with assisting victims and witnesses, as the name suggests. Now, that office is an arm or an extension, how you want to look at it, of the prosecution. That itself isn't unreasonable necessarily, but what happens is that sometimes they have their own agenda, which isn't quite the same as the complainant or victim's agenda. That happens most often where there's a false allegation and maybe the complainant wants to recant, and that doesn't fit with the prosecution's narrative, and there you get complications. And certainly that might be a good time for the complainant to retain his own lawyer. Now, the Victim Witness Assistance Program, as I said, is an agency, is an arm of the prosecution, the Crown's office. So they talk to the Crown. Now, the Crown is the Crown Attorney, the Assistant Crown Attorney is typically the person I talk to. I'm a lawyer, they're lawyers, we speak the same language, we get along. And finally, I speak to my client, the accused. And so you can see there's a whole bunch of degrees of separation between the complainant and the accused. And there's probably a bail condition saying they can't talk to each other anyway. So that structure is important to note. And one can come to a lot of, and that structure is intentional. And there are certain consequences and implication from this relationship or list of relationships. And one thing that comes to mind is that the criminal litigation process is a horrible dispute resolution mechanism. It's really not designed to fix a relationship between couples, and which is good because it doesn't do that. And I'll certainly leave it to the family lawyers to explain that to us how well family law works. I'm telling you, criminal law does not help to fix the relationships between parties. So if it's not a dispute resolution mechanism, what is it? I would say it's more of, well, I don't think this comes as any great shock. Basically, it's a punishment mechanism. If you commit a crime, we punish you, and that's the end of it. Nothing more, nothing less. Now, what I'll get into that a little bit more. It's really a two-step process, as I alluded to earlier. The first step is the finding that the crime was committed and committed by the accused. And now so that's a fact-finding exercise. It's fact-finding subject to a whole bunch of rules, the burden of proof, the standard of proof, various evidentiary rules, where even if something could prove the offense, it can't be used, and there are pretty good reasons for why that is. And ultimately, if the person is found guilty, then there's a sentencing phase. That's what the process does. It's also important to keep in mind that in this conference, we've been talking quite a bit about problems with the system, systemic problems. We do exactly the opposite. I treat clients as individuals, and ultimately my job is to do what's best for them. And it's very rare that at least within my job, it's very rare that pointing out how the system is flawed really helps my client. It's just isn't the forum. I have to do the best for my client based on how the system is. So those were just some of the points I wanted to make. I know they're probably obvious to most of you, but it really helps to understand when, especially when a person has a grievance against the system didn't work for me, I was mistreated by some party in the system, the police, my lawyer, et cetera. Understanding the structure just really helps to understand why the system may have failed. And I expect that, well, I'm not here to apologize for the system, but it may be that I may be an apologist for the system. And that might be addressed in the question and answer. Thank you.
Thank you. Okay, I'll go next. Can you hear me? Okay.
Yep.
We're worried about online as well. Because I have. All right. So my name's Jenny Kirshen. I'm one of the lawyers at the Gene C. Coleman Family Law Center. For the last 6 years, I've been practicing exclusively family law. At our firm, we specialize in complex cases. Norman. You've got brand new batteries here. One moment, please. Yeah, okay. So I've been practicing exclusively family law for the last 6 years. Our firm focuses on complex cases. We deal with a lot of children's issues, parenting time, decision-making. We handle protection applications and families that have involvement with various children's aid societies. We do cases of parental alienation, false allegations, and often we find that these cases also have complex financial issues. So spousal support, child support, property division. Our firm is known for our work with fathers' rights, but similar to some of the presenters earlier today, we don't necessarily like to categorize it as fathers' rights. It really is about the children's right and the children's right to have a relationship with both of their parents, to get the love and the support and the benefit of a relationship with both of their parents, and to see, what each of their parents has to offer them. Gene Coleman, some of you may have attended his session just now. He is an academic and he's a proponent for the presumption of equal shared parenting. And because of that, the lawyers at our firm are really committed to helping families, particularly dads, maintain and enhance their parent-child relationships. We are very in tune, and one of the things I want to talk to you guys about is the bias against men that exists in the court system. In my cases and in my experience, I've seen this, most predominantly when it comes to parenting, and very often when there are younger children. There are issues in our court system that are unique to fathers. Men have to, and dads have to fight harder than moms to maintain relationships with their children. They have to fight much harder to have equal time with their children. And this fight takes both an emotional and stressful toll, both on the parent and on the entire parental family. But via, some of our clients, we are starting to challenge some of these outdated norms. For example, the idea that, mother knows best. There's also the primary caregiver argument, which exists a lot with younger children. We see that the judges, even the male judges, are buying into these outdated norms. Earlier in my career, I had 2 very factually similar cases, one in Woodstock, one in Kingston, both with younger children. In both cases, when the parents separated, the mom left with the children, was initially withholding parenting time for dad.
And then eventually would give dad a little bit of time, but it was a struggle at every stage. In both cases, the dads admitted that during the marriage, the mom did spend more time with the children, but that was just a function of dad having to go out and earn a living. Wasn't dad's fault. That was the roles that the parents decided to take on. In both cases, there were some resist refuse dynamics with one of the children and the dad. In both cases, they were good dads. In both cases, there were allegations of substance abuse that were overblown by the moms. And what we were able to do was so moms were using these overblown allegations to try and make the dad look deficient. In one case, there was allegations of alcohol abuse, and we had the dad voluntarily wear an ankle monitoring bracelet to show that there was no alcohol dependency. In the other case, there were allegations of marijuana use, and we had the father's primary care physician who had a relationship with him that the primary care physician had been monitoring his marijuana use. We had that physician provide an affidavit to the court that his marijuana use would not affect his parenting time, and it wasn't a dependency. We had interim motions in both cases during the same summer and got two very different results. So in the Woodstock case, the judge really got it. She awarded dad equal shared parenting time and recognized that the pre-separation parental roles were not determinative of the post-separation realities of a now separated family where dad had the responsibility to step up and take on an equal role, even though that wasn't necessarily the case during the marriage. Unfortunately, the Kingston judge didn't get it. And this is where we see the bias. Dad was awarded 4 out of 14 nights. The judge recognized or decided, rather than recognize that because the children had spent most of their life in their mother's care, that would be in their best interest to continue mostly in their mother's care. The judge ignored that status quo was artificially created by the mother post-separation because she was refusing to allow the dad to have more time. In that case, the judge actually commended dad for being a great dad, doing all the right things, all the child-focused things, but still the judge felt that it would be too much of a disturbance for the children to change their parenting time schedule to equal shared parenting at that time. And that judge wasn't prepared to make an equal shared parenting order. So personally, arguing those two cases in a very similar time frame and seeing the way that the courts treated the two cases differently tells me that some judges are getting it and there is some movement being made, but there still is bias, unfortunately, in the system. We've also seen, I've seen cases where the outdated norms and the bias take a turn and it results in parental alienation, false allegations. And I think those of us who attended in the Rosedale room this morning heard a lot more about false allegations and parental alienation. So I'm going to not get into that in as much detail, but just to say that these are the most difficult and most emotional cases for dads. The allegations extend not only to the alienated parent, but to the entire family. These cases become difficult because children's aid societies get involved. The police sometimes get involved, and when there are criminal charges, it is essential that the criminal lawyer and the family lawyer work together, check each other's pleadings, know what's going on in each other's cases, to make sure that they coordinate so that what is said in one case doesn't negatively impact the other case. When Sue asked me to give this talk, she said that there would be lots of attendees here who may be the subject of some of these allegations or who may be finding themselves in court. So I thought I would end off with just some general tips. So I think a good tip, if it's your first meeting with a lawyer, the best thing you can do is to keep your documents organized. Send the lawyer ahead of time a clean electronic copy of your continuing record. Once you have a lawyer, you have to be patient. You have to understand that the courts are slow, the waiting times are long, and court time is very scarce. If you're looking to get disclosure, it takes time to get disclosure orders. And once you have that order, it takes time for these collaterals, professionals, children's aid societies to produce the disclosure, and then it can take a significant amount of time to actually review the disclosure. If you have engaged a lawyer, communication tips include sending emails in point form, using charts whenever possible. If there are financial issues, use Excel to your advantage. When you name documents, use easy to follow names so that the lawyer knows what you're sending them. Use file formats that are widely accepted, like Word documents and PDF. PDF is the best. Answer your lawyer's questions efficiently. And when you're emailing your lawyer, group your questions by theme and use headlines in your emails. If you can't afford to have a lawyer or you're self-represented, the best thing you can do is read the local notice to professions or practice directions. Those give essential information about filing, page limits, deadlines, and court procedure. Those are available through the Ministry of the Attorney General websites. If you can afford to even hire a lawyer to do unbundled services, that can go a long way. A lawyer can help you prepare documents in an organized way that will maximize the chances that a judge will read the document and understand what's in there. Most parental alienation and false allegations cases end in motions because it's extremely expensive to go to trial, and motions are decided on the basis of affidavit evidence. So having a lawyer help you prepare those documents can make a huge difference. For all litigants, use free technology to your advantage. So apps like PDF Sam, which is a great free app for manipulating PDFs, Scanner Pro, a free app that turns your cell phone into a scanner, and Touch Copy is a great one if you're trying to send your lawyer text messages and correspondence. You can have your messages line by line rather than in those very space-consuming bubbles. Touch Copy. So PDF Sam, Scanner Pro, and Touch Copy. We have a question. Yes. Touch Copy. And there are several of them. These are ones that I often use, but I know there are several great apps for downloading text messages. And I think the last tip is set up and use a support network. So I'm sure a lot of you attended the We for He panel yesterday, and we learned from that panel that there's significant amounts of documents in these types of cases. They can be extremely onerous for one person. So use your family, use your friends, set up a support network that can help you, that can help your lawyer. Your family members and your close friends have the firsthand knowledge of the events that occurred, and that can be priceless. So get those people on your team.
Anyone hear me?
Maybe you turn.
Oh,
No. Okay, I'm sorry.
Hello.
Yes.
All right, so my name is Jake, and I'm a criminal defense lawyer in Toronto, but with Zoom, I guess I can practice anywhere in Ontario. But anyways, so before I became a lawyer, I was actually a police officer in the city of Toronto. And I did that for about 8 years, and then I went to law school. And after that, I articled at an agency called Office of the Independent Police Review Director, which is basically an agency under the Ministry of Attorney General. It's an agency that investigates all the alleged police misconduct in Ontario. So it's a bit like a provincial-wide internal affair. So I article there, I was a summer student and I went back for my articling and then I left and opened up my own shop. So that's my background. So I'm going to talk about the legal issues, probably more from the enforcement side, right? So here in Ontario, in Canada, actually, the officer can make an arrest based on a legal standard called the reasonable and proper grounds. RPGs, right? It's not the rocket propelled grenades. It's the reasonable proper grounds. Yeah. So, which is actually the second lowest legal standard threshold in the criminal, at least the criminal law world. The lowest they call reasonable suspicion. The second lowest is reasonable and proper grounds, which is not very high standards. It has two components. One is called a subjective component. One is an objective component. Subjective component is the officer's perception. So what the officer thinks about the situation. And then the objective component is whether the officer's subjective decision was also objectively reasonable. Who decides that? A judge, right? In a judge alone trial, or a jury in a judge and jury trial. Okay, that's the person that makes the assessment. So, but at the investigative stage, I would say it's actually very, very subjective. I give you a scenario. Let's say in a domestic situation, right? Husband calls 911 or wife calls 911 and say, my wife or my husband pushed me, right? An officer shows up, no third-party independent witnesses, no injuries, right? How can this officer decide, right? What's the reasonable proper grounds? Basically, it's a two conflicting version of the story. One says he did it. The other person says, no, I did not do that. So where do you go, right? And to make the situation worse is in Ontario, at least there's a provincial mandate. It says when you have a reasonable proper grounds, you meaning a police officer, you shall make the arrest, right? It's not like a you may, it's mandatory, no more discretion. When I was at the Ontario Police College, so every police cadet, right? When a person was hired by a police service, the person became a cadet, and then the person will be sent to Ontario Police College, which is just outside London in a small township called Elmer, to receive provincial trainings, right? So you have to have a minimum 3 months of training. And then larger agencies like Toronto Police Service, they have called a pre-Elmer training, pre-OPC training, and post-OPC trainings. So during my training at the OPC, we were told there's a study that suggests a complainant usually is abused 26 times before they actually come forward and report abuse, right? So that's why domestic related offenses are highly dangerous, right? And we hear this crazy stories. The husband abused the wife so many times, but the wife never reports to the police. And guess what happened? The husband eventually murdered this wife, okay? So we were programmed to believe that every domestic situation, if we don't do something, will evolve into a homicide, right? So that's how at least we were programmed when I was a police officer. So then the question came, what's the definition of abuse, right? Like the previous speaker mentioned that the most abused word is abuse, right? What is abuse, right? You're nodding at me, is abusing me, because you're not saying anything to me, right? So I'm just joking, right?
Get out. Give me your badge.
So what is abuse, right? Where did that number come from? We were never told, right? And the other problem is, because when I became a police officer, like I said, okay, we have to make an arrest, right? Mandatory. So somebody called the police, we have to do something. We have to make an arrest. But the problem is, and oftentimes when we slap the handcuffs on somebody, on the husband or on the wife, the other party freaks out, right? They say, oh, who's going to pick up the kids? Who's going to drop off the kids? Who's going to pay the bill? I said, we don't care. We don't know. See ya, right? So then I heard that few times, right? You already from the wife and sometimes even from the kids, because the husband and wife, they are not calling the police, the kids call the police, right? Right, the kids thought that he was or she was doing the right thing, but who knows, right? And then they often say, oh, guess what? I would never call the police again, right? Because they felt re-victimized by the system, right? Not, they call the police thinking, oh, the police gonna show up and caution the other party and everybody just carry on, right? But no, mandatory arrest. So we just intervene, we step in and we extract a member of the family out of this family, right? And then we slap them with an undertaking and, or sometimes even bail recognizance, right? Saying you cannot have direct and indirect communication with the other party, blah, blah, blah. You can't even be near where the party is known to be. So the arrestee cannot even go home, right? So it's just basically the person missing in action for the next several months until the court proceeding is over, right? So then we often hear the complaint and say, I would never call the police again, right? And because it's not helping, it's actually making the situation worse because there is a re-victimization, the system, right? So then I say, okay, so has anyone done any study, right? This mandatory policy has been in place for so long. Has the reporting of domestic crime gone up or gone down, right? If it has gone up, then it doesn't work, right? If it has gone down, then my next question is, how many people stopped reporting because of the system, right? So I don't know. No one has done it. Seems like no one has done any research on that. So I don't know. I don't have the number, right? But as a frontline enforcer, law enforcement officer, as back then I was, and it's just a daily reality that we see every day, multiple times every day, right? So now as a lawyer, I would say the officer sometimes is very, very hard when there are two conflicting versions of the event with no evidence or independent witness to suggest which one is more believable. The officer just basically based on who called police first, pretty much. It's in a race to the telephone, right? Who calls police first? So then the case goes to court, right? And then they retain a lawyer. And the officers are really busy, especially in Toronto, right? They don't have the time, they don't have the resources to do a very thorough investigation, right? So oftentimes through my own investigation, right? So as a lawyer, I sometimes, if the clients can afford it, I will hire a PI, private investigator, to do their own investigation. I can tell you, there are a lot of falsified or exaggerated allegations. Okay, I have a client, for example, facing 19 charges. Okay, just one girl pick up the phone, calls police, and he faced 19 charges. And the Crown has dropped 16 charges. The three remaining is scheduled to be dropped. Okay, because the little investigation that I did contradicted the complainant's statements. Okay, so and this is not the only case. I have a case where the client was charged with 26 charges, right? So the Crown dropped to 20, so he pled guilty to some, but didn't go back to jail, right? So it's very, very real, the false allegation. I don't have the numbers, so I can't say the percentage. I can't say 10%, 20%, 30%, but those are very real. And it's very, very unlikely the police will go back and to lay the charge and say, call it public mischief, right? Public mischief is you misuse police resources, right? Very, very, very rarely I see that, right? And the Crown is very, very reluctant to prosecute such a public mischief, right? So that's the reality, right? So is the system of course is not perfect, right? It creates all the issues. So that's a bit unfortunate, right? And but however, the upside is at least we have the Constitution, right? We have charter. We are all presumed to be innocent, right? Reasonable proper ground is the second lowest legal standard. But in order to prove someone that is guilty, right, a judge has to be satisfied with the beyond reasonable doubt standard, which is the highest legal standard. It's very high. No one can say how high that is, but the legal term is it's much closer to certainty than balance of a probability. Balance of a probability is a 50%, right? So maybe in the 80, maybe in the 90 range, right? So that's so it's hard. So a lot of people get charged, but they're not necessarily found guilty or convicted. Okay, so that's how important the presumption of innocence is. At least in Canada, we have that, right? In some other jurisdictions, in China, we don't even have that.
I just asked, when you said that you would hire a private investigator, was that to investigate the police investigation?
They are, okay, I always say, if you look at my website, I put that on my website. In many criminal defense work is actually a investigation of a police investigation. Okay. So the investigation there, I would say, it really depends on the case. Is to investigate police misconduct, for example, sometimes, right? Whether the officer used excessive force, whether the officer breached somebody's charter rights, right? And they lied about it, right? And but then there also the investigation to pick up what the officer had missed, right? For example, text messages, surveillance videos, right? And many times officers, they don't even bother. And I had a private investigator to go to the place and talk to the property manager and get the video, and it shows the evidence is so powerful. Right? I even went back to the officer and say, why don't you just go back and charge the complainants, the public mischief? They were like, we don't do that. So like, what do you mean you don't do that? Do you have reasonable public grounds? Right? That's the reality, right? So there are two aspects to it. One is to investigate the police misconduct, to investigate what they did wrong. And one aspect is to investigate what they didn't investigate, right? Yeah. So I'm gonna talk about CAS very briefly, and I'm gonna pass the mic on to my colleague here. So the CAS, when it comes to domestic assaults, right, or any allegation involves a domestic setting, including husband, wife, ex-wife, same-sex, ex-boyfriend, ex-girlfriend, they're all called domestic by provincial definition. So if there's kids involved or being present, or the officer know that you have a kid, they will call the CAS, okay? And the CAS will notify it, and they will do an interview, okay? Be careful with the interview, because the CAS say, oh, it's just to us, it's just the CAS, we're not gonna report to the police, which may not be true. Okay, sometimes the CAS, they do talk to the police, they do talk to the Crown. And also, the parents can always get a copy of the CAS report, right? I'm just saying the wife calls the police on the husband get arrested. The wife can always go to CS and ask for a copy of the CS interview notes and a report. The wife can forward this copy of the notes and the report to the police, to the Crown, okay? And I have seen it. It was a case where the kids made an allegation against the mother because the mother did not buy him the Frappuccino, right? And he got really upset. So then he calls the police and say, mother removed his belt, slashed him numerous times, dragged him from the kitchen all the way to the living room. And then the police showed up, they take the photos, and I say there are no welts, right? No rock rash, no marks, nothing. The skin is as clean and smooth as a baby seal, right? A clear fabrication. And then what's funny is 2 weeks later, after mother was arrested, 2 weeks later, he actually went to the CES and say, I made it up. It was not true. Please let my mommy come home. And the CES made a notes in the report saying the kids was lying. I said, based on what did you know the kids was lying? Maybe the kids was lying. Why didn't you just say the kids was lying to the police, right? When the kids made a fabrication, made the allegation. Why did you say the kids was lying to you when he was saying that he was lying to the police, right? It's based on what? Nothing. There's subjective mind. So don't trust CS, okay? Because you don't know what they put in the reports, right? They may come across very friendly, very engaging. It's a trap, right? It's just like a police officer trying to interview an accused person, right? I always tell my clients, the nicer the police officers are, the more dangerous and sneaky they are. Why? Because I was one of them. I got trained on that. Okay. my job was to get you talking when I was a police officer, right? So I had to let you guard down. I will play dumb if I have to, right? I will stroke your ego, make you the smartest person in the room, right? So I was trained to do all that, right? So same as the CS, okay? And so that's why I always say, if you can have a lawyer, ask your lawyer to be present during the CS interview. You are entitled to a lawyer during the CS interview. If you don't have a lawyer, the CS always asks the question, one question: what happened that day? Shut up, shut up, and shut up. Okay? Okay.
So hello, my name is Jean-Jacques Desgranges. I'm from Ottawa. I became a lawyer on the late side. I was a little older than most. It was in 1997, after spending time in oil, in construction and teaching, many things. So a good part of my life was with my boots on the ground, knowing a lot of things. And so from there, you learn a lot. But motivation for me becoming a lawyer was in fact having to pay so much for a lawyer. And so it's a bit of a joke, but in fact, it is true. I figured I might as well just go to law school and see what that's all about. And it might be funny, but just remember that the first year of law school, I recommend to anybody anywhere, because with those tools in that first year of law school, I can probably get that without going to law school for that. But it helps you through the rest of anything in your life, including contracts, including, if you're hiring a plumber, whatever it might be. It's just a recommendation, but I'm off topic right now. So I'll come back and I'll come back to family law. So my role now, basically, since 97, it's more general law practice. I help people out, and I've got another full-time job, which kind of rounds up the months. The fact is, though, that after I met Justin Trottier many years ago, probably 2016, we set up the CCMF in Ottawa, and then I started the Family Law Clinic, which eventually became virtual. So at this point in time, every Tuesday, more or less, I get people calling in and they have questions, and it's not a legal clinic, it's actually a legal information clinic. And there's a big difference between both, because I'm not representing anyone. But I have to say that service seems to have done a lot of good to most of the people who came through the clinic. And hopefully this will grow, this service will grow. As I say, we're not giving specific advice. We're doing a little bit like Jake did here, just saying like, shut up and shut up and shut up, for example, okay? A few words before we get to the questions. The CAS is absolutely right. Always, no matter when they're questioning me, they are trained as social workers. And social worker schools these days especially have a bias that needs to be taken into account. And so, yes, don't say anything, have someone present. There's one thing you need to have, despite CAS and whatnot, and I think that counts as well for you, Jenny, and everyone. The secret, because I get these questions that come up, and it's false allegations all the time. But most people forget is that you have to have evidence, clear-cut, strong evidence. And these days, telephones capture everything. So therefore, when the police come, and if you can take their two seconds aside, and they pull you as the assumed perpetrator, put you in the car, you're able to say, wait a minute here, have a look. Don't give them your phone though. Yeah. But have a look. And once they can make up their mind on that, then they might go back and get the actual perpetrator as opposed to the person who's accused at that point. There is that training. I'm glad that you raised that, the training, the fact that for the longest time, the police training is well, if you don't know who did it, take the man away. And so one way to get rid of that is to have the evidence. So evidence. If you don't have that, at least take the time to write a diary up saying this is what happened. And later on, that will help, at least as written down evidence, to back up your story. Because as Brian Nudmer said, the science of memory is one that forgets, right? Okay, so immediately write it down because that's going to help you. There's a word to say about peace bonds as well. Most people who are arrested will be asked to sign a peace bond. And you had another name for that, release conditions or something like that. At any rate, that's a very dangerous piece because that, contrary to a criminal record, you can never get a pardon on that. And so by simply signing it, even though it doesn't say, I confess to this, it's taken as such in family courts, okay? And so, and yeah, things kind of go south usually from there. You want to see your kids, anything for peace, you sign it, but you don't realize sometimes where it's going to take you. Not saying it happens all the time, but more often than not, I've seen that create more havoc than anything. So you might as well hold your ground, spend the night in jail, try to figure things out the next day. And then after that, move on with the lawyers if you can hire one. If not, well, call the clinic or get legal aid if you're entitled to have that. So that's I've got plenty of things I can say here. Those are the two. Oh no, there's another aspect. Something called the sealing order. CAS will often, well, we'll take notes and everything. Will block you from getting that because it doesn't involve you. You see, the notes they took about the situation has information that pertains to mom and the child, and you're not allowed to see that, right? Because it's private information all of a sudden, because you're no longer part of that picture. And so there's a sealing order process that goes in. They want to seal it so you cannot see it, and so it creates a huge issue. Now, fortunately, it takes motions, it takes time, it takes money. The lawyer can have access to that and see what's in there. But it gets very frustrating, especially for someone who's not represented, to see what's actually in those files. Okay, and what did the CAS actually note down? And yes, indeed, sometimes you'll see that it's not totally objective. It's not as objective as it should be. So just remember that, and there's a process. Just to let you, I'm now involved in a situation where we're trying to get that. We're going to judicial review at this point because the privacy commissioner refused, and so we're now having this reviewed, and hopefully we'll win this. Hopefully that'll be not before February, I think, but hopefully we'll be able to get something that will allow disclosure, so we can actually show the case. The odd thing in here is we know everything. We've got papers to show it. We just want this to be public so that anybody else who's in the same situation can have access and see, oh, got it. Now we can move on. So that, you got to work the law from both ends. Sometimes it's good, sometimes it's bad, sometimes you have to open it up. And if we happen to do that, there's going to be someone that comes behind, as Jenny said, going to change that again and say, well, it's not quite right. We're going to fine tune it here, or otherwise just say no. That's about all. Those are mostly the evidence and the sealing orders I wanted to talk about. Other than that, let's take questions. I think a lot of time has gone by now. So.
Question. So do we have a mic that we can share? And maybe you can come here so we don't have to run to anyone at that time. If there are any questions.
Can I respond?
Yes, yes. Why don't you respond and then you guys talk amongst.
Yeah.
Go ahead.
Because of the microphone, I really don't want to make it a back and forth with my colleagues, but I just wrote myself some notes. Response to Jenny when she said that her cases were the most emotional cases. She's absolutely right. People are emotionally invested in their family court with their custody and stuff way more than going to jail. It's weird, but that's the way it is. And cooperate, between the family lawyer and the civil and the criminal lawyer. Yeah. I also agree with that. Jenny's been 100% correct. Yay, Jenny, yeah. As a criminal lawyer, I have the benefit of having asymmetric disclosure rights. We don't have to tell the Crown anything. They have to tell us everything. So by that very nature, we tend to hold our cards very close to our chest. So we kind of want the family lawyer to go first and get statements from everybody before we go. Sometimes it works, sometimes it doesn't. Little response to Jake. It's one thing when the police are involved and she says he hit me and he says, no, I didn't hit her. That's one problem. But change the facts a little bit. She says he hit me. He says nothing. You have to admit, in that second scenario, it's more likely that he's going to get arrested. Funny thing is, if at that point you called a criminal lawyer and said, hey, should I talk or not? The answer is still don't. Whatever you have to say can be said at trial rather than told to the police where it might get misinterpreted. It might be that you just don't know the law. So like, it might be that what you say she did actually wasn't a crime, or your explanation or your defense actually might be a crime. There's so many possibilities. The answer is still don't talk, even in that situation. Finally, a little response to Jean-Jacques with respect to peace bonds. Peace bonds have a few uses. At least in a typical criminal law context, the use is that in exchange for you entering into the peace bond, the Crown withdraws the criminal charge, which is good. Now, there are some situations in which even a peace bond is unacceptable to the accused. And my suggestion under those circumstances is instead of doing the peace bond, which is basically a set of conditions, you just basically stay on bail for a year. You go stay on bail for a year, come back to court in a year, they withdraw the charge without a peace bond. Same result, same period of supervision. It's an option. Sometimes not the best option, but it's not a bad option.
So yeah, I just have a couple of comments. Yeah, that was a lot of really good advice. Jake, first police officer I've met since 2013 that I actually like. So yeah, thank you. Yeah, and so we had a long history with CAS. We were former foster parents, and CAS kind of turned on our family and in 2013, and when they turned on our family, all contact was cut off, all support was cut off from CAS. The workers that would come to our house try to separate our family into different rooms and try to talk to our kids separate from us. One of the first things we did was have a lawyer appointed to our kids. So whenever a worker came into our house, I would get them I would interview them. I'd get them to state their name, the date, the time, tell them that they were being recorded, and if they were wanting to take notes, before they brought a pen into our house, I'd say that I want to review the notes before they leave. So I would review all the notes, have them sign it, X out the bottom of the page. But yeah, we recorded every interview that was done with myself, with my ex-wife, and my two kids, and that was really helpful during the not only the family court. It didn't really get to that point in the criminal trial, but yeah, for sure in the family court. But yeah, just wanted to thank all of you.
I've been at this, thank you very much, the four of you, for this wonderful presentation. I've been at this conference for 2 days, and I've listened to a lot about bad-mouthing the other parent and this alienation that is caused with children. And when I got divorced, which was a very amiable divorce, and it was in Alberta, you know, we didn't have any of these problems at all. We just decided we didn't like each other and we were going to get divorced. But it was mandatory in that province that if you were going to get a divorce, you had to go to counseling, and the court made you go. And listening to all of this stuff this week, there's something really wrong with these people who would do these kinds of things. So is that not a provision in Ontario that these people should go to counseling before, is it?
Well, congratulations on your divorce.
Thank you. It was very amiable.
The only requirement for family law litigants is to go to what's called a mandatory information program. And it's about, I think, an hour, an hour or two. It's a session about the process and the court process, but there is no mandatory counseling.
Now, that being said, there is an obligation on family lawyers to recommend before going. That's probably the first thing we're supposed to say after taking ID and making sure they can pay the bill. What we need to do is at least tell them that, you know, let's look at reconciliation. Is it possible? That's the one thing. Then if they say no, it's just a matter of process, we have to do it. But then after that, the process does not say mandatory counseling. Generally speaking, what I find is the clients in the clinic that I get, it's way past there. The counseling is no, I mean, you can't fix something when the cops were brought in. You can't fix it that easily when the kids have been alienated. But by the time you get a court date, unless it's an emergency motion, there's a lot of time that's gone by. So counseling does really help. And when one party made up their mind about something, usually they've made out their minds. Like the human mind can be quite cruel at times. So what can I say? We've seen it in history. And so, yeah, sorry.
Okay, Jenny, what is the source of the bias that you described in family law system? And how is it maintained? What can you say about that?
It's a good question. I think the source, I think I heard this earlier today, is this idea that, there's been this 300,000 years of patriarchy and violence against women is so prevalent, and that's just what's at the forefront of people's minds. What can be done about it? I think, again, at this conference, I've heard a lot of really good things. I think there's just a lack of education for the judges about violence against dads and men, and lack of education for the judges about the abuse that happens against the men. I think there's a lot of training. I know, and there's domestic violence training that family lawyers are encouraged to get. In the domestic violence trainings that I've done, there's never been the male identified necessarily as the victim.
That's interesting, but I actually meant something a bit different. The second part of my question was, how is it maintained? And I mean, you may not know the answer to this, but I mean specifically, like I've heard this 2 days of this conference, we've been receiving a lot of information about, for example, partner violence and the data that's coming up over and over again. That's been, we've known, anybody who works in the area has known for a very long time what the data indicates, and that is not the dominant narrative. It's being maintained in a certain way by certain actions, by certain people, by certain interests. Are you, you're talking more generally, and what you say makes sense. Have you may not been able to observe the origins, but I don't think this is just cultural lag. If it was created at some point, but it is being maintained. There is an active maintenance of the bias in the family law system. If there is a preference, if fathers are selectively disadvantaged in custody battles, which I understand is the case, if men are facing a disadvantage, whether accusations of partner violence, there are humans that are actually maintaining this narrative.
So I'll just jump in at this point. Okay, so I think you can go back at least 60 years at this point where the push started. It has to do with, and I dare say this, but I might get castrated to use the proper word. The feminism took over, which is something I was totally for. I mean, all of us were. I mean, equal work, equal pay, all of these concepts were good, but within that, there was a group that went off and vilified men. And so my experience at this point is that the institutions that are out there, and they may be governments, they may be not-for-profit organizations, who actually, and these institutions get most of the money from the governments that are out there, are actually, I dare not say encouraged, but feeding this, and won't let it go away. No. I won't, but
Actually,
you,
I'm sure. This, Church also just put out a call about a month ago or so, and the money is at. And the money, the funding is asking for all research about gender-based violence against women and girls. And it just came out,
but it's also,
and it's,
to a large extent, it's feeding on itself, because if, it's like the grants you ask certain government levels these days. If you don't put in what they want, I mean, typical example is the one about the federal government not giving grants if you opposed abortion, a few years ago. Okay, oh, that's your view, you're not getting any money. So that kind of attitude that goes around. And of course, is whatever's at the forefront up there. Okay, well, what's popular? What will make people vote for us? What will do this? And so there's the political game that plays in. There's the social game. There's the fact that I suggest probably having a look at the curriculum of social worker schools. You had, okay. Right, and so, yeah, I think that was Lloyd, was he? Yeah. Anyways, and so if and this, of course, doesn't go away immediately as you go out in the working world. And when you start working with these organizations, the same things come back and you're encouraged, right? You're not encouraged to question very much. So what's maintaining it? I think that's what it is. And this side of the equation, so to speak, has not been very good at getting things together to sort of put a stop to that.
Okay, thank you for your wonderful presentation. I'm just curious, like, how do you maintain the communication or maybe the coordination between the service providers? I mean, especially the psychologist and the, lawyers support. Like when you make a referral to a psychologist, then how do you know the progress or, the compliance to the psychological services? Is there any formal process? Thank you.
So in my experience from the family law perspective, it's normal. I get my clients to sign an authorization that says that I can really communicate with the therapist or collateral or whoever it might be. And then when I need an update, I can check in and ask for one. If the collateral wants, if the collateral wants to give me an update, they have, free reign to email me, check in with me. And then I also depend a lot on the client to tell me this is the progress of the therapy, this is what we're working on, this, something good happens, something bad happens, this was a roadblock, and it's not formal in my experience.
Yeah, I haven't dealt very much with that. I do know that when it comes to parental mediation on the children, there's something called the Office of the Children's Lawyer, and often they'll consult to know more about the children, but they'll consult social workers. Clients I've had, they weren't really specific clients, but I always say, stay away from that. Insist on having a psychopedagogue, is that what they're called? Yeah. Okay, someone who's actually knows about the psyche of children. Brian spoke about that earlier, but I think it's much more than just saying, oh yeah, they're experts. Remember, these days experts are just about anybody out there. And so, yeah, they're experts, they're social workers, which I always had a hard time with that. Like, some of them are fantastic, I know that, but others are moved by, their preconceived notions, whereas psychology is much more solid. So I don't know if that answers your questions, but I had to sort of.
Yeah, I have a question for you, Jenny. It's a twofold question, and it's LGBT related. It's rather personal, but I'm not really afraid of. Finally got rid of the fear of exposure. So one is 20 years ago, I had a legal separation, and there was a full release at the end of it. And I'm just wondering if there is something's lingering still within me, and I feel like is there a possibility to open that case again? Once there has been a full release. Yeah.
When you say a full release, you mean like a separation agreement?
Yes. There's a
Potentially, without knowing a little bit more about the facts, it would be hard to say, but I think likely yes, but I think it's hard to say at this point.
No.
Yeah.
Yeah, look, it's like, anyone can actually file a civil suit against you tomorrow. Without anything, just, I'm suing you just because I don't like you. It's a bit the same way, although here you have something that was signed by two consenting adults who knew what they were getting to and everything. Unfortunately, in family, or fortunately, depending on the situation, it's there to haunt you, because if something doesn't work out, the other party can come back to get more, for instance.
There was a prenup, but it was never really used. But thank you. I will be in touch somehow. The other question is, it's a relationship for 27 years with a man who is closeted. And I've sort of given him refuge for that amount of period of time. And there was somebody who spoke about it recently about false accusations. And I'm coming to terms. I've actually ended the relationship. And I just want to know what would be my rights. There's no assets involved or anything like that. But the refuge was really not giving him, not revealing his identity. And that was it. For whatever, for material stuff or family reasons or public structure.
Yeah, so common law spouses have rights. I think, again, it's very hard to give an opinion or to tell you about a particular case in this type of a forum, but absolutely, are you asking about sort of exploring formalizing the separation?
Well, there were no assets and actually we did live together.
Okay,
But
So
I'm
you
just
may-
wondering what are my rights? I mean, it is 27 years here.
so potentially there are claims, I mean, it's maybe spousal support. I don't know. It's very hard for me to say without knowing a bit more about the facts of the case. Yeah.
Thank you.
I'm just wondering about the peace bond issue. If the Crown is willing to negotiate down to a peace bond, why bother? Why not just call them on it and say, I won't accept a peace bond? Have a trial if you think we ought to have one. Obviously, if they're talking about a peace bond, they don't want to have a trial.
So let me answer this question first, and then Toro has more to say. Each Crown office in Ontario has a Crown manual, which their internal, more like a rule and procedure, which is about 1,000 pages, right? Even not more. So it will pretty much tell the Crown what to do, right? Especially at the resolution stage. So peace bond is, I would say, not very rarely you will convince the Crown to drop the charge. First of all, it's not that easy to convince the Crown to drop the charge without going to trial, right? So you have to meet certain thresholds, right? So even if you can somehow, based on the personal circumstances or evidence, whatever, you can, as a defense lawyer, you can persuade the Crown to drop the charge. I would say 10 out of 10, the Crown will come back and say, sign a peace bond, right? Take it or leave it. What are you gonna do? Are you really gonna advise your clients to spend thousands, maybe tens of thousands of dollars to go to trial, facing the possibility of a finding of guilt, when the Crown is presented to you with a deal of a peace bond, and then drop the charges, right?
Well, the bottom line is that the Crown isn't going to fight.
Fight what?
They aren't going to have the trial. That's why they're offering you the peace bond. And
That's
then,
it.
then when you turn the peace bond down,
Yeah,
then they turn around and say,
Yeah.
well, we can have a hearing to impose a peace bond on you. And the answer then is, that's fantastic, because we're going to bring all of this out so we can use it in family court. And let's have a hearing, because if I lose that, I don't get a criminal conviction or anything else.
peace
I
bond
get a peace
is,
bond out of it. And that's costing them a lot of money. So they're not going to have the hearing anyway. That's a bluff.
you mean the Crown?
Yes.
No, actually, the Crown office, they will say, take it or leave it. Okay, they will say, oh, you want to go to trial, let's go to trial. We don't care, because they really don't care. Because why? Because they're just a cog in the machine, right? They are not personally invested in the outcome. They're supposed to be the Minister of Justice. They're supposed to be neutral. And the Crown that says, oh, you don't want to sign a peace bond, take it to trial, may not even be the Crown run the trial down the road, right? Because the Crown is is not a person. So they're not, I would disagree, they calling that a bluff. It's basically a negotiation, right? So somebody can both walk away from the table with something in their hands. Okay, it's a business negotiation, more like at that stage. So if you say, you say, oh, you know what, so if you don't really want to prosecute it, so that's why you give me the peace bond, then I'm gonna call you on the bluff, and let's say I'm not taking this peace bond, let's see what you're gonna do. Well, very likely what's gonna happen is they're gonna say, take it or leave it, and if you don't take it, let's go to trial.
Well, I'm only experienced with a few cases, but when I've told people that, they've done that. And the Crown has come back and says, well, we can have a hearing to impose the peace bond. I said, "Let's
Technically,
go."
technically, yes, they can. It's called a contested, it's a contested hearing, called a show cause hearing, right? So you have to, the Crown show cause of why the peace bond is necessary in the
They're not
case.
willing to spend the money on having a hearing like that, which is basically the same as the trial, just to impose a peace bond on somebody.
It's like you're playing you go to the casino and play the game, and somebody say, well, if you drop, you do this, I give you $10. And if you keep on playing, you may lose $1 million. What are you gonna do? Right? Are you gonna really take the risk of losing $1 million? Probably not, right? So it's a tough decision, but well, at least in Toronto, a lot of those Superior Court judges, because I think the family court cases go to the Superior Court, they all preside over criminal cases. They kind of understands in many cases that the peace bond is just a result of a negotiation. It doesn't really mean that the person was an abuser, and they draw the negative inferences from the fact that there was a peace bond sometime in the past. Right. So, but this is just my my observation. But speaking of that, family proceedings. I haven't seen it yet, but it is possible someone during the family proceeding may confess to past criminal acts that they committed, but not charged. So sometimes I give the civil lawyers, not just family lawyers, but civil lawyers, advice and ask them to invoke Section 5 under the Canada Evidence Act to get their full protection. Okay, because because I've seen civil proceedings, civil litigations, not family. The person actually was about to to confess his past criminal acts in a discovery process, a proceeding. So I asked the civil lawyer to invoke Section 5 under the CEA. So that's something that you need to be careful for when you are participating in a family proceeding.
What about civil lawsuits against false allegations?
It is possible. It's a claim under the torts. So it is possible. I have never seen one. The case that I just mentioned, there was clients got dozens of charges. The family is contemplating on that, but again, it's just, whether they're going to proceed or not, I don't know.
And, on many of these types of cases, are there many civil lawsuits going on against the police for laying charges when there's really no basis whatsoever for doing that? When the case is thrown out?
Well, the case is thrown out for a variety of reasons. You cannot just say because of the case is thrown out, so the police made a mistake, it was a wrongdoing. Like I explained, the police make an arrest based on reasonable public grounds, which is the second lowest legal standard. To prove someone that is guilty, you have to reach the highest legal threshold called beyond reasonable doubt, right? So there's quite a gap, right? So someone that is arrested but not found guilty, it happens all the time. You cannot say the police officer made a mistake. The officer made a mistake because the court did not find this person guilty. No.
And it can be extremely damaging to someone to have charges laid where there was no foundation whatsoever for having those charges laid, and there's no civil remedy for that.
So there has been, it was a friend of mine, Mr. Klippenstein, who actually brought that to court, and they actually won the G20 when there were certain actions on the part of the on the police. So yes, there is recourse, but you have to remember in tort, you don't have a case if there's no damage that you can actually show, and that actually shows that it's set back. Otherwise, you don't even have a case if you can't show that you need reparation of some sort. So if your reputation is ruined and you lost a contract for $100,000 or $1 million, you might have something, but by and large, most people in those situations don't have such contracts or whatever. That's tort law 101, so to speak. Tara, do you want to say something? I'm gonna add just a little bit about, this is a question for you guys here. The peace bond, my experience, and it's a very brief one. When there was a peace bond, the sign says, don't sign that, it's bad. And then, and of course, the Crown didn't like that. But then my next move was to say, I want full disclosure. And once they started giving the full disclosure, it took 3 months, mind you, but once the disclosure came out and you knew what it was about, they dropped it at that point. They just said, we're not going to pursue this, right? So give or take, I don't know, but you can actually ask disclosure after peace bond, after someone decides not to. This is the way it worked for me. I'm not a criminal lawyer. It worked that time. I don't know if it will.
So all the Crown office, based on my observation, they will give you called an initial disclosure package, which tends to be incomplete. Okay. But as the lawyer, you need to ask the Crown what you need, right? You don't really have to explain to the Crown why you need those, but you have to put in a request and send to the Crown office. If you don't send the request, very unlikely they will voluntarily provide you with all the disclosures that you want. But you, as a defense lawyer, you have to know the case, right? So you have to know where to look, where to poke, to know what is relevant and what can be disclosed, right? For example, I had a case in Napanee because I wasn't a former police officer, so I asked a bunch of disclosure. The Crown didn't even know existed, right? Because I was a police officer, so I knew how the officer operates. So I knew those were available. So I put in a very specific request and I get the disclosure. And then in the disclosure, the officer actually made a racial slur, right? Basically beat up on my client and saying my client was the aggressor. Prior to that, he actually made a racial slur, and the Crown office just dropped all the charges. But you have to know, as a lawyer, you have to know where to look, what to ask, and it's the Crown's obligation to disclose, but also the defense lawyer has I would say, an obligation to make the request, right? So back to the scenario, if I were the lawyer, I would ask everything that I think is relevant prior to signing the peace bond. Okay, so I can have a full review of what is available, and to put me in a better position to negotiate with the Crown. But you have to be careful because sometimes you got the disclosure is can be very damning too, right? Put you in a worse position to negotiate with the Crown.
I'm going to try not to overlap answers. Jake covered most of it. One thing I wanted to say was that the resolution of criminal cases by peace bond or otherwise is a resource allocation issue. It's not an admission that the Crown has no case. So if you're offered a peace bond and you turn it down, one risk is that you go to trial and lose. That may be a high risk, low risk, I don't know, but it's a risk. The second, and you probably have no idea what the risk is as the accused. The second thing is that if you're offered a peace bond, you turn it down, the Crown wants to save resources by not prosecuting you fully, but they could prosecute you. Basically, they can get peace bonds out of 10 other guys, take your matter to trial, maybe win, maybe lose, and the resource allocation reasoning still stands. And one further thing to add, I can't remember it. Sorry, one more.
I have a
It's-
question.
Sorry, it's just back to the peace bond, because so when my clients go to court and take the peace bond, I always say to the court, my clients enters into the peace bond voluntarily, and she does not admit any criminal or civil liabilities. Just put on the records as a protection, right? Who knows exactly, right? Who knows? So I always say that, right? So it's hopefully I don't know what that helps when it comes to civil and family proceeding, but it's just something on the records.
Just for the family proceeding, just to be clear, what happens is that, a fair lawyer probably wouldn't go get that, but most of them do, so to speak. And it's not to say that all lawyers are unfair, but the fact is you're defending your client. And if your client is the one who wants to show that the other parent is not fit, any piece of evidence is good and that counts, and it is often put into the file at one point or another.
And what about using evidence in the criminal proceedings in the family law? So in the criminal, you can go right after the other party, prove this is a false allegation, and then use it in the family law.
The criminal court does not prove false allegations, okay? The criminal court, if you take your case to trial and at the end of the end of the trial, you do not win any criminal trials. There's no winning in criminal trial. Why? Because the court will never say, oh, you won the trial. They only say you are not found guilty. They do not say you're proven innocent.
I'm talking about using the evidence from this person and the witness in the criminal trial, to use that evidence in the family.
It's possible from the rule of evidence.
It's possible, but it's not that simple. So, for example, if you get a Crown brief or you get disclosure in your criminal law file, you can't just all of a sudden hand that file over to your family law lawyer for your family law lawyer to now use in your family law proceeding. There's a legal principle called the deemed undertaking rule, and it prevents documents or evidence from one proceeding being used in another. So your family lawyer would then have to go and apply to the Crown to get the disclosure themselves. And this is one of the challenging things of being involved in these types of cases, is that you're doing a lot of these things twice. So you know the information that's in that Crown brief and you just want to be able to use it in your family law case, but it's not that simple.
Yeah, but what I was talking about was a transcript of a witness at a criminal trial being used in the family case.
Yes, I'm just very quickly touch on that. Yes, it is possible. The trial transcript can be used in family courts, in other proceedings, not necessarily family. So that is why you gotta be really careful, offer the peace bond, then say, oh, I'm gonna take it to trial, because whatever you say in the trial may be used as evidence in other proceedings, right? So probably from a tactical and a strategical standpoint, you may actually not want to take the case to a criminal trial, right? Sometimes it's probably better just take the peace bonds. In many cases, I would say it's probably better just to take the peace bond, because if you take this case to trial and then you create a transcript, create a records, and so that records can be used in other proceedings.